This is a new series. You read along with me the rules of criminal procedure. So for your criminal procedure, there are 18 rules, and that is from your Rule 110 up to Rule 127. So this is what we are going to do. We are going to read each and every provision of that 18 rules para pag dumating kayo sa review or a-attend kayo ng mga klase, hindi kayo aantukin because you already know the 18 rules. Mas madali din intindihin ang remedial law if you know the rules from the beginning up to the end. You have that full grasp of the process. So we begin with Rule 110, and that is the prosecution of offenses. Let's go to Section 1, that is the institution of criminal action. But first, what is a criminal action? Take note ha, yung definition ng criminal action, tinatanong yan sa bar exams. In fact, naitanong na yan. And that is a very, very big mistake if you cannot answer what is a criminal action. The answer can be found in your Rule 1, Section 3. A criminal action is one by which the state prosecutes a person for an act or omission punishable by law. So how do you institute a criminal action? The answer is it depends. Bakit it depends? Because take note, if you are going to file your criminal action outside of Metro Manila or outside of the chartered city, iba ang procedure. And then if you are going to file it also in Metro Manila or other chartered cities, then iba din ang procedure. So let's talk about first outside of Metro Manila or other chartered cities. So how do you institute a criminal action? Again, you have to make a distinction. Dalawa ulit. You have to take note of 421. Ano ba itong 421? Parang lotto number lang. Your 421 is very important because that is your Section 1 of Rule 112. If the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine, then PI is required to be conducted. PI is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 to 1. And if PI is required, ano ang sinasabi ng Section 1, letter A, then you institute the criminal action by filing the complaint with the proper officer for the purpose of conducting the required preliminary investigation. That proper officer refers to those persons who are authorized to conduct PI. So, prosecutor. So you file a complaint with the city prosecutor or the provincial prosecutor for the purpose of conducting the PI. And again, opposite ng 421 is of course your less than 421, less than 4 years, 2 months, and 1 day. So in that case, ano naman ang procedure pag ang penalty is less than 421? For all other offenses, that is your letter B. Take note that you have two options. Ito ang nakakalimutan ng mga estudyante. Akala lang nila is you just file a complaint or information directly with the MTC. They don't include that you also have that alternative wherein you can also file a complaint with the office of the prosecutor. So you have two options, either direct filing with the MTC or the MCTC, or go to the office of the prosecutor. So we are done with the outside of Metro Manila. How about if you are in Metro Manila or other chartered cities? So how do you institute a criminal action? There is only one way, isa lang. And that is you file a complaint with the office of the prosecutor unless otherwise provided in their charters. So again, if you will be asked, how do you institute a criminal action? The answer is, it depends. Nasa Metro Manila ba siya and other chartered cities, or outside Metro Manila? Then you have to make a distinction, 421 or less than 421. Take note of the last sentence or the last paragraph of your section 1 because it talks about the effect. The effect if you are going to institute or file a criminal action. So what is the effect? The answer is, it will interrupt the running period of prescription of the offense charged unless otherwise provided in special laws. So again ha, hindi yung pagpa-file ng case sa korte, but rather the institution of the criminal action that interrupts the period of prescription. And when can you say that there is an institution of criminal action? Kakadiscuss pa lang natin. What did we say? There are two ways as long as you meet the requirements. The first is you can file a complaint with the office of the prosecutor, or you can file directly with the MTC or MCTC as long as the penalty is less than 421. Ang tawag nila dito sa practice is direct filing. So, take note ha, kahit nasa prosecutor's level pa lang yung kaso, it can already interrupt the period of prescription. Let's go now to your section 2, the complaint or information. Section 2 talks about the general requirements of your complaint or information. Here is an example of your information and a sample of your complaint. Take note of the caption para yan sa legal writing ninyo. So, what are the general requirements? Number 1, it should be in writing. Number 2, it should be in the name of the people of the Philippines. So, your plaintiff is the people of the Philippines. Take note ha, yung plaintiff mo, hindi yung taong ni-rape, hindi yung taong ninakawan, kundi ang buong sambayanan ng Pilipinas, the 110 million population of the Philippines. And who is your accused? You should name all your accused against all persons who appear to be responsible for the offense involved. So, kung yung nagnakaw ay isang grupo, you name them, you include them in your information, pangalanan mo silang lahat. Let's go to the complaint. Take note na yung complaint na sinasabi ng Section 2, it does not refer to that complaint filed in the prosecutor's level. Ang tamang pangalan nun is complaint affidavit. But that complaint affidavit filed in the prosecutor's level, that is required for purposes of preliminary investigation. You are going to file a complaint affidavit for purposes of preliminary investigation. But the complaint referred to here in Section 2, this is about the purpose of this complaint rather is to commence a criminal prosecution. Kaya magkaiba yung complaint sa prosecutor's level kaysa sa complaint na sinasabi dito sa Section 2. Let's go to Section 3, the definition of your complaint. A complaint is a sworn written statement charging a person with an offense. So here is our example of our complaint. Again, take note of the caption, the general requirements, the plaintiff, the accused, and number 1, again, the definition is you are charging a person, Mr. Lodka, in this sample, of the crime of acts of lasciviousness. Number 2, the complaint must be subscribed by the offended party. In our example, this is Miss Ayaw Ko. Or it can be subscribed not only by the offended party but any peace officer. That peace officer refers to a police officer or an NBI agent or other public officer. But take note that itong public officer, hindi lamang kung sino-sinong public officer. He must be charged with the enforcement of the law violated. Like for example, your BIR officials, as long as they are charged with the enforcement of the criminal aspect of your NIRC rules, or the customs officials. Let's go to section 4, the definition of your information. It is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So here is an example of your information. Again, take note of the caption and the general requirements, the plaintiffs and the accused, and you are accusing in writing these three individuals of the crime of robbery in an inhabited place. And sino ang nakapirma? Dapat ang nakapirma is the prosecutor. In our example, it is the assistant city prosecutor, and it must be filed in the court or with the court. In our example, branch 84 of Quezon City, because para magkaroon ng information, ang premise is tapos na ang preliminary investigation, tapos na ang executive determination of probable cause. Naitanong na sa bar exams, difference between a complaint and an information. So kahit hindi ninyo nabasa yung mga red notes, blue notes, green notes, as long as you know your section 3 and section 4, again, we start with the similarity. They both charge a person with an offense, but the difference is in your complaint, pwedeng pirmahan ng offended party, peace officer or public officer, as long as that public officer is in charge with the enforcement of the law violated. Whereas your information, isa lang ang pwedeng pumirma, at yun ay ang prosecutor. At ang information ay dapat na i-file na sa court, filed with the court. That is not the case of your complaint.